Hey out there, legal warriors. I'm going to cover something very specific that's overlooked often in court, and that's called conditions of release. If you're interested in criminal law, if you might be involved in something with a crime or a court date, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. This is an overlooked area of a criminal court case, and a very important one, and I'm going to cover it from top to bottom about what are typical conditions of release, when are conditions of release set, how can they be changed, and what happens if you violate a condition of release. So, what are you talking about, Lance? Well, a condition of release is typically where we go before a judge, a defendant does, someone either arrested for a crime or actually charged for a crime, and the judge is supposed to set conditions of release to protect the public from the alleged wrongdoer. Now, we're presumed innocent, which I think really doesn't seem that way in court. But technically we're presumed innocent, yet this court can set conditions on us that restrict our freedom and even hold us in jail while the court case goes on. And so what is the court supposed to do? Well, they're supposed to set the least restrictive conditions necessary to protect the public and to assure the reappearance of the charged or arrested person in court for future court dates. Now, that's pretty broad, and it's pretty much the judge can do whatever they want, because the judge is basically the courtroom version of a god, where they can say what they want and they have broad discretion. Now, supposedly their conditions of release are supposed to be tied to the sort of the criminal behavior. If we're charged with a DUI, a condition of release should not be don't go on the internet. If we get charged with something more serious, like, possession of illegal images, then maybe don't go on the internet would be a valid condition of release. But standard conditions of release that don't have any type of special restrictions would be stay in contact with your attorney, get an attorney, don't commit any crimes, keep your address updated with the court, and appear for all future court dates. If that's all you get, then you got away with basically the minimum that you could have done. A condition of release in a DUI case typically would be those standard conditions, possibly abstain from alcohol or mood-altering drugs, don't drive without an interlock in your car, or even wear a Lindsay Lohan bracelet, a Scram bracelet, where it detects whether or not you have alcohol in your system. Stuff like that. What about a domestic violence case? Well, conditions of release might be don't have any contact with an alleged victim. Don't go to the house of the alleged victim or the workplace, something like that. And that might even throw you out of your own house. And in those cases, the condition of release will probably be added to an actual no contact order. And let me go through that difference now. What's the difference between a no contact order and a condition of release that says don't have any contact with somebody? And this applies to assault cases, domestic violence cases. It could apply to anything where there's an actual human being victim. Well, if it's just a condition of release and is written down on paper, that means it's not going to be monitored in law enforcement databases, right? There's a condition of release for you not to have contact with Mr. X, and you're somewhere and have contact with Mr. X, you're in the car, you get pulled over in a whole different city. They're not going to be able to look up that that's a condition of release. And as long as you keep your mouth shut, you're probably going to drive away. Right now, if the court finds out about it, then the court can do something, and we'll cover that next. Now, if there's a formal no contact order, and that's an order under a certain statute that says don't have contact with the victim, and then that gets entered into a law enforcement database. And wherever you get pulled over, at least if in Washington State in this case, the law enforcement officer would be able to see that's in the system. And if you are with Mr. X, now you're going to get arrested and charged with a whole new crime. So we need to obey both, but there's a much more serious consequence, a whole new crime, if we violate a no contact order by having contact with an alleged victim versus us violating a condition of release. So let's, before I move on to what happens when you violate a condition of release, let's take a step back. How do we hear about and learn about our conditions of release? Well, it typically happens at your first time in front of the judge, either a first appearance if you're not charged yet officially, if you're just arrested, or at an arraignment, which typically starts a criminal proceeding where you are charged. The prosecutor is going to ask for conditions of release. Your defense attorney is going to argue for certain conditions of release or agree if they're standard. And then the judge gets to set it. So what do we need to do? We need to listen up. We need to listen up to what the court says, and they will give you your conditions of release in writing. And if they don't, you need to ask for them in writing, and you need to make sure you review them and see what they say. So conditions of release are set at that first appearance by the judge, and they're in writing. And with all these Zoom hearings nowadays, it's sometimes hard to get a copy. There's something called O-Court, there's electronic court, and so you're going to want to work with your attorney to make sure you get your copy of conditions of release. So moving on, I'm going to call it number 2 here. If we violate a condition of release, what happens? And also, how does someone find out if we violate a condition of release? Well, if we violate a condition of release and the court finds out about it, then the court on its own can set a motion to change your conditions of release, or the prosecutor can bring a motion to change your conditions of release. And that's putting it nicely. When I say change your conditions of release, that usually means put you in jail. Put you in jail while the case is going forward. So how does someone like the court or the prosecutor find out if there's a violation of condition of release? Well, if the victim's against you and you contact the victim, they might call the prosecutor and tell him. If your condition of release is don't have a new crime, and that's pretty much every time that's going to be a condition, and the prosecutor or the court clerk or the judge sees that you've been charged with a new crime because they've got a database that shows all that, then that might come up at your next court hearing. You're going to want to let your attorney know if you've had a new crime so they know to take some countermeasures to have a better chance of you not getting put in jail. There's things we can do. And another way they can find out is, let's say you had alcohol monitoring. They say don't drink. Well, maybe the probation department gets a report that you drank, or the court gets a report that you drank from a treatment agency or from a smart start device you're blowing into. Anything like that can tell them. So procedurally what happens, it may just be addressed at your next court date, or it may be special set for you to come in where the judge can decide what to do. So if they say, I'm revoking your release, what happens? Well, most of the time, the court's going to set a bail. They're not going to typically want to hold you in custody this whole time. They'll typically set a bail, and there's some exceptions where they may not. But if they set a bail, that means you need to post some money or a bond by paying a bonding company to get out of jail. So how they find out about a violation of the condition of release, those type of ways. What happens if you violate a condition of release? Typically, they'll either modify the conditions or put you in jail and then make you post some bail to get out. So the last thing I want to cover is, how do you change a condition of release? Let's say you don't like the condition of release. How do you change it? And I'll use an example from some recent life in our office. So let's say you're charged with a DUI and it doesn't look very good, sort of a bad looking case. Maybe there's an accident, maybe it's a high breath test, maybe the person charged isn't cooperative. Well, the prosecutor might say, hey, I want this defendant to wear Scram, which costs about $500 a month. It's something you put on your ankle, and it supposedly registers if there's alcohol in your system. There's a lot of flaws with it, but that's what it supposedly does. And that's really onerous. It's really difficult. It's uncomfortable. It's buzzing all the time. It's doing all this weird stuff. And let's say you don't want to wear that for 6 months while this case is going on. Well, what might you do to change the condition of release? Well, you might change your position. In a case like that, we might send someone to get an alcohol and drug evaluation. show they don't have a problem with alcohol, or show if they do need treatment that they're compliant with treatment and they're getting random UAs. In either case, now there's more information. We could set a motion in front of the court to change the conditions of release. They're not forever. Either side can move to change them. We just have to have a reason. And so in a case like that, we'd present the alcohol evaluation. If treatment was required, we'd present proof of treatment, say, look, the least restricted alternative no longer requires scram. Hopefully there's been no violation for the month or 2 months the client's had it. So judge, we think it's safe to remove the condition. So don't be afraid to ask your attorney and remind them that you have a certain condition you want changed, because especially the very popular, the effective and good attorneys out there, they're going to have a lot of different clients. And while we want to be perfect and remembering everything about your case, we can't be, nobody can be, right? And so remind, if there's a condition you want to try to get changed, speak up, ask about it to your attorney, and then your attorney will have a better chance to help you get better conditions as hopefully your case goes towards some type of successful resolution. So that's about it for conditions of release. They're overlooked. They're very important. They're very frustrating, but I want you to realize what they are, what happens if we violate them, how they find out about us violating them, and that we can change them. So if you find this video useful, please like and please subscribe. More people will see it. And even more importantly, if you have a legal problem in Washington State, feel free to give our office a call. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.